When most people hear private investigator, they picture surveillance, a camera, a parked car, perhaps someone following a cheating spouse. That image makes for good fiction. But in legal work, investigation usually begins somewhere quieter, with a question. What happened? Who was involved? Where are the records? Who saw it? Does the timeline hold up? And what evidence might be missing? Police detectives and private investigators may begin with the same questions. Both may interview witnesses, review records, test timelines, examine digital evidence, and document what they find. The important difference is not whether they look for facts. It is who they work for, and the legal channel those facts enter. A police detective develops facts for the government. A private investigator may develop facts for the defense, an attorney, a business, an insurer, or another private party. And the court has a different role from either investigator. The court is not part of the prosecution team. It does not investigate for the police or build the defense case. It is the judicial authority that supervises the process, resolves legal disputes, and applies the law. In a criminal case, the proper framework is not the police and the court against the accused. The state presents its case. The defense tests that case. The court acts as the neutral judicial authority overseeing the contest. That distinction is the foundation for everything that follows. Both police detectives and private investigators can ask for cooperation. Either may knock on a door. Either may request an interview. Either may ask a witness to explain what happened, or ask whether records can be provided voluntarily. But a request is not the same thing as a legal command. Police have powers that private investigators do not. Even so, an investigator's request, standing alone, does not become a warrant, subpoena, or court order simply because the investigator made it. When compulsory authority is needed, the matter must move through the lawful process available in that case. The investigator develops facts. A prosecutor or defense attorney evaluates their legal significance. And when judicial authorization is required, the court determines whether the governing standard has been met. Put simply, investigators ask questions and develop facts. Legal process supplies compulsion. On the state side, a police detective may interview witnesses, review records, document evidence, and prepare reports. Those facts may support further government action. A prosecutor evaluates the case and determines what legal step may be appropriate. If the state seeks a search warrant, for example, facts supporting probable cause must be presented through the proper process, and a judge or magistrate decides whether the standard has been satisfied. The warrant is not the detective's personal command. It is legal authority based on a defined legal standard. The defense side has its own pathway. A private investigator may identify witnesses, locate records, preserve online evidence, test statements, reconstruct timelines, or uncover inconsistencies and gaps. The investigator then gives that factual work to defense counsel. Counsel decides its legal significance and may use the procedures available in that case, such as subpoenas, discovery requests, expert review, motions, or applications for court orders. The private investigator does not personally command a witness to appear or a record holder to produce documents. But the investigator may identify the witness, locate the record, explain why it matters, and give counsel the factual foundation needed to pursue lawful process. That is the defense side parallel. The two sides are not equal in power. Police may exercise governmental authority that private investigators do not possess. Prosecutors can bring criminal charges. Private investigators and defense attorneys cannot. But there is still an important structural parallel. Police investigation supports prosecution-side legal action. Private investigation supports defense-side legal action. On both sides, investigators develop facts, attorneys determine legal strategy, and courts supervise or enforce judicial process when required. Different powers, parallel structure. Many investigations never begin with compulsion at all. They begin because someone agrees to talk. A business voluntarily provides a record, or one source identifies another. Voluntary cooperation is normal investigative work. Police detectives request it. Private investigators do too. If voluntary cooperation is not available, the investigator does not simply manufacture authority. The next step depends on the law, the kind of case, and the tools available to the attorney or government agency involved. That is why facts matter. Facts help determine whether another lawful step is justified and which step that should be. The American legal system relies on adversarial testing. The prosecution presents its evidence, the defense examines and challenges it. The court ensures that the process follows the law. That system cannot work well unless the defense has a meaningful way to investigate. A defense investigator may ask questions the original investigation did not answer. Who else saw what happened? Which records were never collected? Was the timeline tested or merely assumed? What digital evidence should be preserved? Which statement conflicts with another? What fact supports an alternative explanation? That is not an effort to obstruct justice. It is an effort to determine whether the evidence is complete, accurate, and provable. A private investigator does not need police power to be useful. The record that changes a timeline, the witness who is overlooked, the inconsistency that requires explanation, or the digital evidence that needs preservation may change how an attorney understands the entire case. At Interlink, our role is evidence-driven fact development. For defense counsel, civil attorneys, businesses, insurers, and private clients, we identify, preserve, and analyze the records, digital evidence, witness information, and timeline details that may shape a matter. We clarify what can be documented, what remains uncertain, and what the evidence actually supports. We do not replace the police, the attorney, or the court. We give attorneys and clients a stronger factual foundation for decisions, negotiations, legal challenges, and trial preparation. If your matter turns on an incomplete timeline, overlooked evidence, or digital records that require closer examination, Interlink is prepared to help. A serious investigation begins with a question, then it follows the facts.